So for performance evaluations, we can't grieve the procedures, the use or the content in an evaluation in a teacher termination proceeding. So these are pieces of law that has changed over the past, I'd say 3 to 5 years. But you must have established written evaluation criteria, and you have to implement annual evaluation procedures. There has to be, bottom line, you have to have a board, for us, a board policy talking about evaluation, an implementation process, and set of procedures that are in place. This is an HR nightmare. If you don't have this, you need to have written job descriptions for all of your positions. That way, when you're hiring, or basically at the opposite end of the continuum, right? The life cycle of an employee, they're just coming on. They need to know what is entailed in their job when they're leaving. You also need to be able to say, this is what we needed you to do. This is what we expected, and it was written. It's not something that you just sprung on them afterwards. So those written job descriptions are extremely important from an HR perspective. And bottom line, we have a process for evaluation for all of our contracted staff as well. These are never fun. Reductions in force, RIFs, or terminations. When we have a situation where we are either reducing in force or terminating an employee, we must allow them access to their file. And this is going to, again, reference, and I apologize, but it's referencing page 21 of that chapter 16. So I've tried to note page numbers when there's a listing, as opposed to going through the entire list. But bottom line, we need to make sure that if somebody wants to come look at their file, they can. You agree upon the time that the employee can have access to their file. You have someone from I typically default to district, so that's what I'll do. Someone from the district or the organization would be present during that same time. The employee shall not have access to their references, and they may be charged a reasonable fee if, I think it was on, oops, if they are wanting copies of that. An employer is immune from civil liability unless there's an unreasonable termination or reduction in force. And reduction in force is primarily due to reasons other than employment. So it's typically when student enrollment decreases, and so you have to reduce a teacher. That's the most common reason for a reduction in force. All right, reporting misconduct. So the BOEE, or the Board of Educational Examiners, have a code of ethics and reporting. So there are certain situations where we are required to report to the BOEE misconduct, and those are listed here. I won't take a whole lot of time to go over any one in particular, but they're all pretty self-explanatory, and you can understand why they would be mandatory reporting situations. A safe and healthy workplace, and I apologize, this is again when I'm going to reference pages from that packet. There are about 13 different items on those pages that are related to safety and health for our employees. Bottom line, we want to make sure that we don't have occupational hazards, that we can contain disease management, and boy, are we living that right now, and making sure that we're in compliance with the guidance and mandates that are provided to us. There's training around safety measures, and we have to comply, compliance pieces and documentation, making sure that we enforce those health and safety provisions. There are funds that are available. Typically those are through our operations or our custodial budgets, and we must provide employees with some level of assurance that we are providing a safe workplace for you. Certainly don't like to hear about times when we are needing to visit with OSHA because of complaints around these areas. That also relates back to the violence that we talked about and some student altercation issues. There's a trend of employees making reports to OSHA indicating that they do not have a safe workplace as a result of significant behaviors and violence of students. Dress codes and personal conduct standards. This is, be careful. be very careful about these kinds of things. We have a very broad dress code in our board policy for employees, and our handbook includes that same. We have an employee handbook and a family handbook, and we have a dress code piece in both of those. It is prohibited to have gang-related dress. That's prohibited by our state, so we can adopt a dress code related to that. We do have to have student discipline and behavior policies that are adopted. Our board spends a lot of time. We have a board policy committee, and that policy committee spends a whole lot of time around our policies related to student discipline and behavior. These policies must be provided to our students, our families, and to our teachers and employees. In order to create a safe and respectful environment, we need to make sure that these kinds of things are published in a student handbook. We actually ask all of our families to sign off on an acknowledgement. It's an electronic acknowledgement now of their understanding of these components. Okay, collective bargaining, chapter 20. There are several slides actually around this, and if you are part of the business office, you likely have some knowledge around collective bargaining. It has certainly changed recently. So employees are allowed to collectively bargain or organize under Chapter 20 for the following reasons. It's protections for them. There is a prohibition of strikes by all public employees in Iowa. We'll keep moving. Federal money shall not be jeopardized by Chapter 20, and code provisions that are inconsistent with Chapter 20, should that occur, Chapter 20 will supersede. And if there is a collective bargaining agreement provision that is in conflict, that shall not be final until there's an amendment to the code to remove that conflict. Our employees petition and must have an election for certification of an employee collective bargaining unit. So they have a ballot. They can opt for no bargaining unit or to have a collective bargaining unit. It takes a majority of all the employees in those groups voting in order to certify. And once there is a certified collective bargaining unit, then there's an obligation to bargain and negotiate with them. So as an employer, we have rights and responsibilities around collective bargaining. So you note the powers, duties, and rights here that we have. We have right of assignment. We direct the work of our employees. We hire, promote, demote, not often, but transfer, assign, or reassign our employees. We employ disciplinary actions when appropriate, up to and including termination. As you can see there, we try to maintain the efficiency of our operations, thinking about that public purpose that we have as a public entity using taxpayer dollars. And we determine how our personnel operations are conducted. We take actions to carry out the mission of our systems. And we certainly take care of our budgets and exercise those powers and duties as given to us. When we receive a request to bargain by the employees' organization, then it's our duty to engage in that collective bargaining. It is unlawful for an employer to authorize or condone a strike, to agree to pay somebody even though they're participating in a strike, to pay an increase or some in any aspect to an employee as a result of a strike or something that would violate that subsection here. And that's Iowa Code Chapter 20.12. Subsection 2. It's also unlawful for any representative of employees to authorize, ratify, or participation in any violation of this. So bottom line, no strikes in Iowa, which is what you see again. The employees also have rights under Chapter 20. They have the right to organize. They have the right to negotiate collectively through representatives of their own choosing. That's the certification that we talked about earlier. And they can engage in other activities for the purpose of bargaining. In our district, we have a regular meeting between our association leadership and myself, and we call that contract maintenance. So it's just an opportunity to think about what's in, what are some concerns, what are some issues to be able to resolve prior to any kind of a grievance. So that has, and it's also proving, especially now, to provide a venue for discussion of topics, things that we want to get feedback on or things to consider. We definitely rely on our leadership and our associations to help with that. Our employees also have the right to refuse to join those organizations. That is certainly their right as well. The scope of negotiations, we want to make sure that we are looking at reasonable times, making sure that there's written, there's a notice, public notice of our initial opportunities to bargain, and then just be respectful of the other organization as we're moving forward. We want to negotiate in good faith. As a result of recent changes in Chapter 20, what we negotiate now are base wages. There are other permissible items that we can mutually agree upon as far as to negotiate on, but it is certainly a different world now. No more evaluation. There are other aspects. Our insurance is not in our agreement any longer. There are certain things that are unlawful to include in our bargaining. So we have removed those from our agreements. Neither party is compelled to agree to a proposal or to make a concession. In that kind of a situation, we would be looking at a mediation or an arbitration. Retirement systems are excluded from that, and this references our Iowa Code Chapter 20 again. Prohibited practices would be if we refuse to negotiate, either party refuses to negotiate with the other in good faith. And there is an entire listing here of prohibited practices as well. So it would be a prohibited practice for us as a district, or the an individual who would be representing, sometimes there's a chief negotiator who's listed. This would also be prohibited practices for them. I'll continue to move forward. Our employees also have a list of prohibited practices, and many of those look quite familiar. And again, we're talking about the prohibited practice of striking or boycotting in sympathy as well. So it's not just that we can't strike. If we see that, that there is a strike happening, that we are not boycotting in sympathy with that strike. And this is related to a willful slowdown or stoppage of work that's occurring. That's also prohibited. Right, I will continue to move forward. Obviously, we don't want to have any expression that would contain a threat of either force or removal or promise of benefit. And again, that references Iowa Code Chapter 20. Our association leaders do have an opportunity to have access to teacher mailboxes for distribution of professional literature on their behalf. And we've got some questions now. So we are certainly moving forward quickly now. So I'll let you go ahead and take a look at these. And I think Rob's going to pull up that poll. Here we go. Which are true?
It looks like we've got 10 more people to go here yet.
Thank you.
All right, here are our results.
All right, great. So we have people who recognize that it would be false to say that our organizations and employers may refuse to negotiate in good faith. That is not true. We do have that obligation. We may not engage in a lockout or strike or sympathy sort of boycott. So this is related to that. I don't think we specifically addressed this piece, but this would also be false. Employees may not picket for any unlawful purpose. That is true. So great job on that. And then unions may not contract to boycott or strike in sympathy. Also true. Nice job. So excellent. Thank you. This is probably your wheelhouse, right? Issues around negotiations. So that is great. Thank you. Personnel files and privacy. We talked a little bit about some of these things, so they might be a little bit redundant. We talked about employees have access and could obtain a copy of their personnel file subject to the agreement of time. They don't get access to the references, and again, we may charge reasonable fees for copies made. If you have an electronic system for your personnel files, which would be lovely for you if you're able to have that in a way that your employee could access their own file and they don't need to physically come in and look at a paper set of documents. So this is related to what is considered your property versus the employer's property. You should not have a sense, or employees should not have a sense that materials in their work offices are theirs to the exception of employers coming in and being able to look through work materials, look through workspaces. We can conduct those searches. Certainly many times that would be with a very solid, reasonable suspicion of doing so, but we do have that, that capability. We don't want to have to use that privilege very often, if ever, but we do have it if we need it. Iowa gift law. Here's a fun one. Okay, so bottom line, we are prohibited from, and that also includes one of our immediate family members as a district or public entity employee, public official, from accepting anything valued at more than $3 from a restricted donor. So that will not quite pay for those extravagant vacations, certainly no plane trips, or obviously it would get us a gallon of gas, and that's about, about what we've got right now. Well, maybe a couple, if you can get a really good deal. A gift is defined here by Iowa Code Chapter 68B.2 subsection 9. I think we could probably move forward with that. The analysis of this is really important. Bottom line, is the party a restricted donor? And if yes, you move on. If no, you're good to go. No gift violation, no gift law. If they are a restricted donor, is there an exception? So there are exceptions there, and if yes, and an exception applies, you're good to go. You don't have a violation. If there is not an applicable exception to this list, then you should not accept the gift. So bottom line, talk to your attorney to review before you accept a gift. So if you have any questions, make sure to make that phone call. And then you could sleep at night and you don't have to worry, you've got peace of mind there. So yes, here's the the $3 question, right? Who is a restricted donor? All right, it's a person who is in any of these categories. They're seeking to be a party to anyone or any combination of sales, purchases, contracts, to which either, bottom line, that would benefit the district, or that the contract that the district is proposing. A restricted donor is someone who would personally be or is the agent of a person who would be directly or substantially affected financially by the performance or non-performance of the donee's official duty in a way that's greater than the impact on the public generally. So we have to think about the benefit or to an individual and on the result of a contract or a performance with the district. Plain language, which is good because that wasn't. If a donor stands to benefit in any way from the agency or from the district, then that donor is a restricted donor. So that's the bottom line there. Again, I would always refer you to your school or district council to be able to talk through the situations, because sometimes there are nuances of a situation that your attorney would be able to give you better guidance than any webinar or person who doesn't know the nuances of your own situation. So bottom line, so we know about the restricted donor now. Who is considered a public employee or an official or an immediate family member? Bottom line, if you're employed by a district, if you're employed by AEA, community college, you are a public employee. So this is one I think we're going to use the chat for. What are some common, well, we'll get there, some common exceptions, gifts between family members or exceptions, door prizes, drawings, as long as it's available to the public and not just to you, school district employee, and that you were chosen in a random fashion. Free registration to a conference is an exception only if that's as a speaker or some other aspect that all persons in a similar situation would receive a free registration. Discounts, you know, we see like sometimes bookstores will be 10% off for all teachers, or come to our restaurant between 4 and 6 and you get this discount because you're an educator or something. Those would be common exceptions. Inheritances as well. So here's our chat room. Sorry, I was one slide ahead of myself here. So who would not be considered a restricted donor? And then again, what is that minimum dollar amount? So I'll ask you to go ahead and start typing in that chat. We've got some folks who are already doing that. Thank you. Yes, $3. Oh, somebody is moving ahead. Amory is on it. Yes. Someone that would not benefit. Nice job, Sam. $3 minimum. That's awesome. You guys are on it. Student, yes, 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 yes. Excellent. Great. Teachers would be an interesting, it would depend on that situation. Yep, $3. Yep, students for sure. Awesome. All right, you guys are great. Thank you, thank you, thank you. All right. Not a restricted. So we're moving forward. Nice job. And employee exchange programs and sharing. This is an intriguing notion. So the law permits districts to do an employee exchange program with a term no longer than 12 months. And I've never heard of this March of the Lemons. I've always heard of the Dance of the Lemons. It can't be you take my underperforming employee and I'll take your underperforming employee. It cannot be that kind of a situation. It needs to be mutually beneficial. With our districts, they may also jointly employ an individual in this situation. Yes, well, I'm jumping ahead of myself. Teachers in this kind of a situation are limited to 1 year. There are, especially if we have some of our rural districts here, the SBRC actually can mandate joint employment. So think about that in terms of our sharing as well. Just keep in mind that public funds cannot support voluntary programs that are provided by a non-profit private agency. So we cannot use public funds for that kind of an exchange, employee exchange. All right, moving quickly to staff development. This is something that is a passion of mine. So we have to have professional development for teachers and employees. We have to have a district professional development plan, so a PD plan. Building and individual teachers have professional development plans that are reviewed at least annually. In our district, they're reviewed 3 times a year with the administrator. And that's just what it says. It must be reviewed annually. You could certainly do that more. Our professional development standards are within our Iowa Code, Chapter 256.9. Our district plan around professional development needs to be incorporated into our district's comprehensive school improvement plan. Our district has a strategic plan with specific priorities, and so all of the big goals and initiatives we really tie to that work as well, and it really helps to align. So when we've got that opportunity to have the alignment, it really, I think, makes things much more clear. Funding is received annually in our state aid formula for specific professional development for our teachers. It is divided, for us it's divided, and we call it our core money, and then we have teacher quality money. So there's different ways that our teachers would be able to access funds for professional development purposes. All districts have to have a beginning teacher mentoring and induction program. That's actually part of the teacher leadership and compensation system plan. I believe it's section number 4. Gosh, that's been a while when I was writing that, but I believe that is section 4 related to that mentoring. Oh, goodness sakes, did I go the wrong way there? Nope, we're good. Okay, so we've got mandatory staff development that's also provided. And I apologize again, there are 16 items listed on page 33 of that packet, chapter 16 packet. I can quick do a little flip here and let you know that it's things like the EEOC and the affirmative action training, training around diverse learners, training around parenting skills, human growth and development for parenting, special education paraprofessionals, confidentiality, that hazardous chemicals, materials, bloodborne pathogens. Those are just a sampling of the kinds of things that are listed on that page. All our AEAs provide a lot of this at a very minimal cost, or oftentimes it's free. Again, some of these are also provided by your district's insurance company. If you check out, if we use what's called Safe Schools very often, our employees may or may not appreciate the benefit of that. I may or may not appreciate the benefit of all of those opportunities for online learning, but they're very important, and it's a way to be able to comply and account for all of that learning. Okay. So mentoring programs. Our beginning teachers on those initial license that we talked about at the beginning of our afternoon, they have to participate in a beginning teacher mentoring and induction program for at least 2 years. Those address the Iowa teaching standards, and they have a mentor along with that. Our districts must offer this. In our district, we have a mentor coordinator, and one of our teacher leader stipend roles is a mentor teacher. Oftentimes, districts may use the AEA for this kind of support as well. Again, we talked about at the end of year 2 for a new initial licensed teacher, in order for them to get their standard teaching license, they have to demonstrate proficiency in the Iowa teaching standards. And so this is what this mentoring and induction program is all about. Currently, it's not tied to education reform, but it is part of TLC. And this program needs to be included in the comprehensive school improvement plan as well. Our beginning administrators also have a plan. It is to address the Iowa standards for school administrators, and it is primarily delivered by our SAI, which again is the acronym for School Administrators of Iowa. they provide those administrative mentoring programs, and they do a great job of that. You are probably very well aware as SBOs or aspiring SBOs that there is a mentoring program for SBOs. It's coordinated along with the 2-year program for the authorization. And there are certain requirements for support. And again, I apologize that they're listed on page 35 of that chapter. And so I'm going to quickly reference just a couple of these. The requirements for support. Let's see, candidates must be admitted to the preparation program. All hours in the mentoring program are outside of the 9 semester hours required. There's weekly conversations, maintenance of records of contacts, so you keep a log of your contacts. There's surveys to complete, communication that's required. Those are just a listing of some of the requirements for that support within that chapter. Your participation in this is mandatory. We've got just a couple of more slides here. One is around committees at the district level and advisory councils. And so there's a listing of 8 district level committees, and I'll quickly go over them. Many times if you structure the committees in a way, they could actually serve more than one purpose within the 8 committees that are listed. So there's a Family Support Program Advisory Committee, a Child Development Coordinating Council, School Improvement Advisory Committee, remember that one because we'll come back to it, Advisory Council on Vocational Education, a Gifted and Talented Children Advisory Council, Teacher Quality Committee, Persons with Disabilities Parking Review Committee, and an Education Telecommunications Council. So those are all listed in that chapter 16. One of the most important is SIAC, because again, we put an acronym to everything. So that's that School Improvement Advisory Council. That is a main one. And you really want to make sure and have that operating in a way that is effective in your district, and it could serve multiple purposes. We have that as a way to look at equity as a system. Our SIAC group provides feedback around our district and build district goals, and provides an opportunity for some data analysis and feedback on that. Again, it covers the functions of several if you can set that up correctly. These are in association with, there's very few times do we have accreditation visits any longer. Like we used to have 2 to 3 days of massive stressful meetings with folks, and then they would write a lengthy report around what they've learned about the visit. Now they have a desk audit. If they find discrepancies that are not able to be resolved, that could then result in an accreditation actual visit. We also have required posters that we need to have visible throughout our district, and I will let you know that that's again on page 35. There's a set of, it looks like 9 required posters there. IASB, again, another acronym, which is the Iowa Association of School Boards. They are an extremely helpful entity, just as SAI is to us. They have templates or posters for most all of these required posters. I will quickly go over what those are. Employee rights and responsibilities under FMLA. Your rights under Iowa's minimum wage. Federal minimum wage, or so our Fair Labor Standards Act. Equal employment opportunity, safety and health protection on the job, unemployment insurance, a summary of work-related injuries and illnesses, No Smoking Iowa Smoke-Free Air Act, and the Uniform Services Employment and Reemployment. Those are the required posters that are listed on that page 35. I have covered quite a bit in a short amount of time. But I want to make sure and mention, I added this during one of our breaks. It's noted here, Matt Carver is the legal counsel for School Administrators of Iowa. The phone number for SAI is listed there, and I believe that is his email, although it didn't pop up as a link. I can look at that again, but I'm pretty sure that is. You could also go to the website and you can email him from that venue as well. I've listed my contact information as well. If you have additional questions or would like to have more conversation, feel free to let me know. I may not have answers, but I can certainly find out where to go to get them. I really appreciate the time. We are, according to my my clock right now, we are at 10 minutes still, and I don't know if there's anyone who has a question. Yep, so Jen, I can send you that list of the required posters. I think if we can get a way to get you chapter 16, it would be the last page of that packet. So, but either way, we'll get it to you.
If you send it to me, Carol, I can put that list on the Moodle server so people can see it. Yep.
Okay, that sounds great. All right, I don't have any other sets of information other than I hope you all have a great afternoon and are able to get up and move around and and enjoy what's left of your day. Thank you all for participating. I really appreciate it too.
And we will see everyone next year.
Yes.
For those of you who are continuing.